Your chambers has been existing in the city of Douala, which is the economic capital, for more than 3 decades, with a performance history of successfully managing complex judicial business transactions. Am I correct?
Yes.
Yeah, amongst other areas of expertise.
So it would be inappropriate for us to have this discussion without mentioning the business sector.
Yes.
So the spread of COVID-19 is causing business organizations to consider the need to amend or cancel their contracts. They will also likely be giving thoughts to the allocation of liability and expenses in connection with non-performance. What legal steps should both parties, as employer-employee or B2B, take in order to solve such matters?
I think in matters of contracts, in matters of accords, engagement, it's very important for the parties to agree to terms of engagement, terms of operation, terms of activities. And in most other contracts, we have clauses that resolve this kind of eventualities, such as in any contract, in any commercial contract or business contract, it's unfathomable for there not to be a clause on force majeure. What is force majeure? Force majeure is an unforeseen, unavoidable, unseen, uncontrollable event which happens basically outside your own volition and which thwarts or prevents the execution of a contract or a particular aspect of that contract. COVID-19 is essentially that. It's an act of God. It's what we call force majeure. We could not foresee it, we could not avoid it, and whether you like it or not, it has been the reason behind many unexecuted contracts, many unperformed contracts. When you have a contract between two parties which is unexecuted, which is unperformed, that brings about conflict between those two parties. And I guess your question is, how do those parties resolve it?
Exactly.
Most often than not, it could be resolved either by trying to cure that force majeure. By curing, what do I mean? You can amend your contract to take into consideration that force majeure. You can amend your contract to take into consideration the eventualities of that force majeure, or you redo the contract if you see that matters have taken a turn sufficiently to necessary a redoing of this contract. In those circumstances, those are parties that want to continue working together. Those are parties that understand that conflict is not the end of engagement. In other circumstances, a situation like this could bring about a termination of engagement.
Exactly.
Parties will not want to see eye to eye. You could have somebody who doesn't believe that we need to share the cost of this loss that both of us could not foresee. You have one party that thinks, no, it's not my responsibility, but it happened on your own side of the fence, so you need to take care of it. Force majeure, if you're not able to see eye to eye with the other party, most often than not, it causes for that contract to fail. And as a result, you start hearing litigation. Or what most companies or what most business entities do now, they go to arbitration. Presently with COVID, and in our experience this last couple of months, from I think March to date, we've had, we've received some files, some briefs that have had to do with exactly this kind of scenario. What do the parties do now? You have a ship that you sent with your goods. It's been held off ports. It's still on the high seas for 1 month, 2 months. Now, if you were transporting perishables, they're probably all bad.
Exactly.
That's force majeure, right? Now, if the importer and the shipper are not able to see eye to eye, are not able to sit down and talk and understand that this is not my fault, this is not your fault, let's find a way ahead, this matter inevitably is going to end up in court. And I'm telling you that right now we have a few briefs that are of a similar nature. And on our part, what do? We try to have the parties sit down and talk. Because what does it mean to engage in court proceedings? It's time costly, it's expensive, and there are no guarantees as to the outcome.
Exactly.
So in matters like this, as legal practitioners, we try rather to create a win-win situation between the parties, because a force majeure simply tells you that the inexecution or non-performance or failure of this contract is not, it is not as a result of the actions of any of these parties. You cannot hold at fault any of these parties, and that's why you need to find middle ground. So talking about contracts, talking about engagements, talking about commerce, and how the COVID-19 epidemic, pandemic, global crisis has affected, I would say it's been very, very trenchant. It's been very, very thwarting and very, very challenging. Very, very challenging, both for business people and for us legal practitioners. I think my colleague, senior colleague, might have something to throw light.
Okay, with regard to the business atmosphere, I think force majeure is it's a creature of contract. And as my colleague said, it's very unfathomable to have a contract these days without that particular clause, given that you cannot actually predict what will happen tomorrow. You don't know if there will be a landslide right now, and anything happens. But I think that when that happens, or when you're able to see it happening, there are certain steps that you can take. Either the business partner who is claiming the force majeure can take, and the first things that have to be done is that there has to be a kind of familiarity with your contract, with
Absolutely.
that clause. What does your clause define force majeure as? There are some clauses that are very specific on what can constitute a force majeure. And because they say that force majeure is a creature of contract, if your contract, for example, says that force majeure is for a flood, it's for a hurricane, or it's for a plague, for example, and then it doesn't cover any other thing now, and now we have COVID, for example. How COVID is not a flood, it's not a hurricane, it's not a plague. Exactly. Now, that means that technically COVID doesn't actually fit into the definition of force majeure per your contract. So I think this COVID as well has made people to literally think out of the box with regard to the wording of their force majeure contracts, because it's not everyone people sometimes, and that's why he said it's not advised to just lift up clauses from different contracts to put in, because you need to be able to review and see that that particular clause ties in with the set of circumstances between the parties who are involved. And there is not only the definition of force majeure per the contract, we also have aspects, what's the governing law of the contract. And because the remedies that are available or the procedures sometimes are also depending on the jurisdiction that is the governing law.
Absolutely.
And what force majeure is normally very, very long. Sometimes it's a lengthy clause, because you have to deal with things like the notice period. You have to be able to what's the word again, to notify the other party, because my colleague was talking about the fact that it's an intervening act that you have no control over. But then again, sometimes there could be something that you could have done to mitigate the loss. Mm-hmm. Say, for example, you're supposed to deliver a shipment of goods to this place, and then you come here, and then there's a shipment, then this place here is flooded, for example, and you cannot deliver it here. What are you able to do is you can find another warehouse somewhere to deliver those goods to mitigate the loss that could have been caused. Maybe those goods had to be transited somewhere else or something. So there's always that aspect that the parties that are involved have to do their best or have to do more than what's reasonable to, to mitigate the loss caused as a result of that. And sometimes that involves notifying the other party as soon as possible that this has happened, because there's sometimes a number of days. They say once you realize that there is something that can prevent you or delay your execution of the contract,
Yes.
you have 3 days, you have 4, 5, 6, 7 days within which to notify the other side. Now, 2 weeks have gone by, you haven't said anything. Then you come on the
You haven't said anything
on the 17th day.
And the damage is
It's
excruciating.
going. And then you come after 17 days to tell them that, sorry, we are facing this, but the issue is you didn't, comply with, for example, the notice terms of your contract. So in this kind of scenario, what we usually advise in-house counsel, because sometimes you have big corporations and enterprises that have their in-house counsel that maybe work on those reviews or work on their contracts and then work in hand in glove with the external counsel, that's ourselves. It's normally to have an understanding of that particular clause. Because you need to be able to raise the force majeure within a number of days by sending in your notice. And even sometimes this notice is ongoing. You need to sometimes constantly, regularly update, your business partner on, on the force majeure conditions, on where they're ongoing or if they're reduced, if they're abating, or if it's getting worse. And so there's so many things that, the in-house counsel or the external counsel needs to be very much aware of when they're dealing with force majeure, because it's not just a matter of saying that, oh, it's force majeure, but you also have to prove that force majeure is the substantial or only reason why that contract was not performed. If I can prove that there was another reason why you didn't perform it, like you didn't have money, and you come and want to hang on force majeure, then you might not actually get any relief.
Absolutely.
Because it has to be the only reason. And sometimes some people who maybe are deviant, or when it comes to a point where they realize, oh, finances are not very good, or they start, wishing that they could pull out of the contract, they raise the force majeure issue. But force majeure, you have to establish that that intervening act is the only or the substantial factor that prevented you from actually not executing your obligation under the contract. So
that's the difference between direct and indirect causation. So you could have an act of God, a flood, a hurricane, but insofar as it doesn't prevent you from executing your contract, you cannot rely on that event to say, this is why I couldn't do what I promised to do or what I'm obliged to do. So, absolutely.